Hey, so in regards to motions or affidavit, often you hear a lot of people say, don't file motions in, don't file motions in. You only put affidavits in. That's half truth. That word motion just means to move. See, when you deal with anything relating to inferior laws and the legal aspect, which is the enforcement, the operation of that law, it is very important to mimic nature. And the thing about nature is it's always changing, it's always moving, it's always in motion. So you yourself, you go against nature. The moment you begin to make claims like, we don't put motions in, don't do motions, they're going to deny motions. You only put affidavits in. That's a half truth. You're fooling yourself. All these venues, whether they be court of records or otherwise, they follow parliamentary rules of procedure. Those parliamentary rules of procedures, there are formalities and etiquettes. And with those formalities and etiquettes come certain terminologies. And one of them is called motions. What is a motion? A motion is simply the way that you move any given venue to act upon something. Even if you title your paper affidavit and you put in it, they will classify it as a motion. If you want any decision or consideration to be made regarding that piece of paper that you put in, it will be classified as a motion. So right off the bat, stop lying to yourself about how things work. You heard it from someone somewhere. It sounded good. Now have you tried it? Have you seen how that worked for you? That's the question you ought to ask yourself. If it didn't work for you, and you're saying, oh, they're belligerent, they're bad, they're this and that, maybe you're just not doing it right. Maybe you're just not fully informed. Maybe you're not properly informed. Maybe whoever told you you don't put motions in gave you half of the truth. The truth is you do in fact put affidavits in. Affidavit is your attestation and a verification of the same. Meaning you swear to the truthfulness, you declare, you state to the truthfulness to the best of your knowledge and belief, and then you get witness to it. That is what makes an affidavit. Not merely you saying affidavit of so-and-so, affidavit of fact. And then you make demands in those affidavits. You just don't put it in, and then you sit there and keep quiet, hoping some magic happens. You make demands. You move things. They're called motions. And there are different types of motions for different purposes. So while somebody might have told you that you don't put motions in, you need to stop for a moment and look at what motions mean. Affidavits can be denied also. You know how they do it? They use loopholes against you that you're not aware of. And you acquiesce and waive your right to that affidavit. They don't have to directly attack that affidavit directly. We hear an affidavit that's unrebutted, stands as law. There are many ways for you to waive that right of that fact that you're stipulating in that affidavit. That's what they do to people all the time. The moment you don't move the court to do something, the court being your paperwork, the court and the judge and the law being what you bring in and how you come, they already know they got you. Motions is what moves things. Without it, you have stagnation. And nature itself is never stagnant. Whatever you do when it comes to pen and paper, always mimic nature. And learn and understand what it is that you're doing before you jump into it just because you hear someone say it. Your motion should be affidavit. The motion should be verified by witness, and you should make a declaration and statement to the truthfulness and the correctness. You want to do it under penalty of perjury, do that. If not, cool. You want to do it under the laws of the United States, do it. Or under the laws of the United States of America, do it. Just make sure that you declare to the truthfulness and you have a witness to it. That's what makes an affidavit, not just you saying it's an affidavit. And yes, you do put motions in because that is how you move them. And even if you don't title in a motion for so-and-so, they will look at the nature of the words that you put in that thing you're calling an affidavit. And when they file it and docket it into their system for public record, they will consider it a motion in order for them to make a decision on it. But moving on, this is what motions gets for you. This is an example of a misdemeanor case. The outcome of the motion, the 2 counts were dismissed. A lot of people think, I'm going to go in, I'm going to ask him for a W-9. I'm going to put a W-9 asking for their EIN. And they're going to submit all that, this and that, delegation of authority. When you do a constitutional challenge to the public act or general law of the statute that they're charging you with, that is in fact demanded for the delegation of authority, without leaving them to make that determination by bringing in a third party to intervene, which is called the Attorney General. That is the demand for delegation of authority. Because a constitutional challenge to whatever charge they're bringing to you is challenging the fact that what is the validity of this thing that you're bringing in. Now, the only one that can make a final determination of whether it's constitutional or not is the Attorney General. Why? Because when they bring charges against you, they use the power of the people of the state. If you're in Illinois, it will say people of the state of Illinois. Minnesota, people of the state of Minnesota. Missouri, people of the state of Missouri. New York, people of the state of New York. They are bringing the power of the state against you. And all those other attorneys are working under the Attorney General. This entity, this political subdivision state of, it's like any other entity. They have their police departments, state police. And then they have their attorneys in case somebody sues them or there's a dispute regarding the charges being brought. That police officer, the municipal police employee that arrested you and sued you as the complainant, is an agency of the state. They have the agency of the number. So they're subcontractors for the state. And guess what? The state has an attorney. And that's the Attorney General. All those other public defenders, prosecutors, are simply his deputy. It's that simple. Is there more to it regarding British Accreditation Registry and how they contract with the county and the state? Yes, there is. Generally speaking, the Attorney General is the attorney or the lawyer for the entity that they're bringing the power against you. And since they're using the power of the people against you, it only makes sense for you to bring the Constitution in. Because the Constitution was established by the people. And the state of being a home rule unit has no other power unless it's constitutional. So if an agency of the state is bringing a claim against you, then you have the right to challenge the constitutionality, which is saying, why or how is this statute that you're bringing against me, how is it constitutional? How does it have a standing or capacity to state a claim upon which relief can be granted? And you send a copy of that to the Attorney General. They have 60 days to respond, 60 business days. So it's not necessarily 2 months. And after that, if they don't respond, you move to dismiss because of lack of constitutionality. That is, in fact, a request and a demand for delegation of authority, or a quo warranto, by war warrant. What warrants this action? Is it constitutional or not? That is that right there. So don't get lost in the sauce of quo warranto, do a W-9. And regarding that W-9, that's not even how you use it. The W-9 is a way that you certify that you don't qualify for taxation. And those who you've already done business with, you present that for them to basically give you information for you to do 1099, acquisition, cancellation, whatever it is you want to do. But my question to you, those who submit a W-9 demanding give us your EIN, give us your EIN. How does that deal with the subject matter and the claim they're bringing against you? Yeah, you're saying that it's all commercial in nature, but there's always 2 sides to the coin. In some cases more. So if you're dealing with a commercial aspect and you're overlooking the judicial aspect, they know they got you. They're going to consider everything you put in as frivolous. They're going to turn a blind eye, and they will railroad you. And then at the end of the day, you will have a case lingering for 4, 5, 7 years. Then you're going to go to some group and asking, how do I get this case over with? When you could have done something very simple as a move to dismiss. And that move to dismiss, that motion to dismiss, is itself an affidavit. Put your material fact in, put the Constitution in, put the oath of office in, do all those basic things. So stop lying to yourself about how these things work. Be honest. Get to it. Face the problem. And most of the people that do these W-9, what do you do with it after that? How do you prove that they did in fact issue something from that thing that you're claiming is yours? That social security number, that birth certificate. Where is the forensic audit of that? Do you have all that in the first place? Do you have the forensic audit of the case itself? No, you don't. So when you're presenting W-9 as though it has some validity or some merit to it to get rid of the case, you're wasting your time. What you need to do is get rid of the case as fast as possible. And that is a move to dismiss. Put in the substantive evidence, put in your truth, and get rid of it. So to those who say don't put in motions, don't put in motions. To those who give you the half truth, telling you to put only affidavit in and not move things. When you put in motions in the form of an affidavit and supporting evidence, and you do judicial notice, in some cases you might have to do request for admission. Rule 36 of Federal Rules of Civic Procedure, if you have certain things that's not automatically self-authenticating. So when you put in a move to dismiss, it gets dismissed. And it's really just that simple. All the extra stuff you're doing, you're wasting time. Most people, when they are introduced to things of this nature, what happens is they have a very bad foundation. They are usually in a rush, and they hear something that sounds very good, very smart, very sweet from somebody, or some PDFs. After PDF after PDF, 500, 670 page PDFs. Someone says something that sounds very good, and it's a hype train, and they feel good, and they just run head on into it. How do I know? I've done it. I've fucked up, so I know. And I'm letting you know, you don't have to go through that to get things done properly. You don't have to waste 4 or 5 years of doing things wrong before you actually start doing it right. Because on the other end, they're keeping a paper trail of you. Yeah, it's good to see you've improved. But why waste your time if your life is valuable? Don't waste it on some intellectual jack off. All that stuff people do, they give you about 2% truth and leave the rest. When you do W-9, you're supposed to have forensic audit and all that other stuff. You're supposed to have a right of claim to that thing that you're saying you have a birth certificate to. You're supposed to have perfected the security interest and all that stuff before you begin to do all that. And even if you're going to do the W-9, you wouldn't be demanding it. You will be presenting it to show evidence of the fact that if this is a tax matter, that I don't qualify to be taxed. But even then, people aren't doing it right because it's a certificate that shows what you qualify for when it comes to taxation or not. It's just like a W-8 bin, but people are using it wrong. You read some PDF, you read some Patriot stuff, you read some sovereign citizen stuff, you read some SecuredPartyCreditor stuff. Yeah, it's a lot of info that you read, but at the end of the day, you will read all those PDFs and you will end up more confused, or you would just have engaged in some mental masturbation that just feels good, but now can you actually put it to use? 9 out of 10 times, you don't. So what you do are those basic things to a constitutional challenge that is in fact the core warranto. Accept the judge's oath, do your affirmative defense according to Rule 8 and Rule 12, and put in the material evidence, and then move to dismiss. If they deny the first move, you do it again. Read the complaint. Read the complaint. Read the complaint. And oftentimes, The four corner of the complaint usually contradict the law that they're supposedly charging you with, the public act. So of course they charge you with the statute, but you deal with the actual law itself. So here's a disposition of a case. Brought the claim August 3rd, 2020. They signed the Zoom and all that trash. If you want, if you know what you're doing, you don't have to worry about them muting you. You come in right. This will be a baby step for you. It will be nothing. And guess what? You do file motions. All these are exhibits, and one of them is actually just a motion to dismiss. And even if you do title it an affidavit, they will consider it a motion. It's that simple. They continued it. It's a certified copy of it. And at the end of the day, an order to dismiss on both counts. This is what you want. If you've gone past the 90-day period to remove it to a federal jurisdiction or to a higher court based on the hierarchy of courts in your state, that's fine. You can still kick their ass in their own administrative venue if you know what you're doing. And then you take this as an evidence, and there was no lawful authority to begin with to even arrest you or do whatever they did. That's a alley hoop and a slam dunk for settlement check. Of course, you still have to know how to construct the claim. But this is most of the work done right here. And this is what you want to see. This is what you need. This lady is very happy with whatever it is she was dealing with. So this is what you need. Don't lie to yourself. You do use motions because that is how you move the court. Be truthful to yourself. But your motions will be in form of an affidavit, because all pleadings have to be attested to. There has to be a declaration of its truthfulness, and it must be witnessed. It must be verified. That is what makes an affidavit. You have to move the court. Court is you. Your papers is what move things. Otherwise, it remains stagnant. And you will just be intellectually jacking off. It's going to feel good. You will feel like, oh yes, I'm standing up to the government. I'm doing this. But you're just wasting the time of your life. Somebody has to be honest with you. All this crap about people talking about the government this, the government that. Why are you referring to the government as though it's something external to you? Governments are instituted for the benefit of the people. The people are the one who institute the government. You say supposedly you live in a democracy, government by the people, for the people, even though the Article 4 of the United States Constitution guarantees a republican form. But nonetheless, let's just presume that democracy is for the people, by the people. If that's truly the case, then why are you referring to the government as though it's external from you? It's as though people refer to society as something different. You make up society. You are the government. You make up the government. So you move it to benefit you. You go in there, deal with it, and kick their ass. Stop trying to run away from your problem. Stop trying to do some other stuff on the other side hoping it's going to work. Face it. When you're in a battle, be tactical. But at the end of the day, you have to do the battle. Stop lying to yourself. Stop lying to yourself. All this trend that you don't put emotions, that's a bunch of BS. Be truthful. Be honest. And if you're not truthful and honest, this is the reason why the municipal employees are very comfortable. This is the reason why they can do bullshit and get away with it. Because you're stuck in belligerent mode. You're stuck in struggling and fighting against someone when you've forgotten the power that you have to move things. Be the divine creator that you are. Move reality. Change things. You hear someone tell you you don't put in motion, it sounds good. But did you stop and think about it? Did you look up what a motion is? You look up what the purpose of motions are? Do you know what a court is? You know why and how? Because if you put it in paper saying, hey, you don't have authority over me, this and that, you're trying to move something to occur. And people talk about you don't have jurisdiction. There are different types of jurisdiction: subject matter, personal, territorial, of any jurisdiction. People aren't specific with these things. And when you're not, they know you don't know what you're talking about. Yes, you do put motions in. Your motions are in fact affidavits. And you have to have material evidence to support it. It's necessary. It's the basics of how things work. If you don't know these basic things, and you're saying you want to run after some comprehensive annual financial report account, some CAFR accounts, you're lying to yourself. You're just looking for some easy way out. And that's exactly what they want. They want scapegoats who just want some easy way out to be used as an example to continue the rat race of the cycle. You need to know how this works. At some point, if you really want to get it done, you're going to need these basics. And if you don't have it, you're deceiving yourself. Yes, you do motions to get things done. That is how you move the court.